Hello and welcome to Legally Speaking with me, Tarun Nangia. In our series on Justice Dhananjay Chandrachud, we commence our series today. And in this episode, we're going to discuss his 2-year tenure, which is one of the largest, longest that we have seen in the recent times, and what all he can accomplish, the opportunities that he has, and hope. This is one word that you associate with Justice Dhananjay Chandrachud. There is a lot of hope in the bar, in the business community, in the commercial world, from every spectrum, be it disposal of cases, be it on the digital ecosystem or other issues. We shall delve into that and discuss the gentleman who's going to be taking over as a 50th Chief Justice of India on the 9th of November 2022. May I introduce you my panel today? I have with me Justice Arjun Kumar Sikri, currently known as one of India's foremost arbitrators. It's difficult to get his time, but we finally managed to convince him and he's come. He's also a sitting judge at the Singapore International Commercial Court and one of our most distinguished judges. He served also as the judge of the Supreme Court of India. Good to see you, sir, and looking forward to some interesting inputs from you. I have with me Senior Advocate Parag Tripathi, but let me tell you a story. Two boys started their life in college together. Both went to Harvard. One emerged as one of the top counsels that India has produced, which is Senior Advocate Parag Tripathi, and the other became the Chief Justice of India, that is Justice Dhananjay Chandrachud. So from the same college, we have two toppers. One is one of India's top counsels, the other is the Chief Justice of India. We are lucky to have Senior Advocate Parag Tripathi joining us on the show today. Good to see you, Mr. Tripathi, and looking forward to some interesting anecdotes from you as well. I have with me Ryan Karanjawala, Managing Partner of Karanjawala and Company, which is one of India's leading litigation law firms at the Supreme Court of India for long years now. Any decision taken with regards to administration at the Supreme Court of India, e-courts or anything else has an impact on his and his clients. He will also speak from that vantage point. Also, he has the distinction, as I said, of appearing before both Justice Y.V. Chandrachud, who was earlier the Chief Justice of India, and Justice Dhananjay Chandrachud. So I think I will try and get some anecdotes from that vantage point also. At the outset, let me request Mr. Karanjawala that if you could lay the ground in the first 2-3 minutes before we move on. Over to you, Mr. Karanjawala.
So, Tarun, before the obvious question that comes to mind is, what will be the two contrasting legacies of the two Chief Justice Chandrachuds? But before I come to the particular, I want to step a little back and spend just a minute or so explaining to you what is the significance and the power of the Chief Justice of India. Now, as you know, we've had many prime ministers, some of whom have held the have been on the world stage. Nehru, possibly Mrs. Gandhi, Prime Minister Modi, all of them have sort of fought their way to the high table as far as world leaders go. But in contrast, the Chief Justice of India, by the very nature of his power, is the most powerful judge in the world. And there are 5 separate reasons why this is so. First, he presides over the largest population, 1.3 billion people. Second, the jurisdiction of the Supreme Court is quite unique. Any and every matter, no matter how big or how small, can, if the litigant so chooses, ultimately find its way all the way up to the Supreme Court. And their power extends not only to striking down legislation, but also to striking down constitutional amendments. Third, they have been given the power under Article 142 to do what they feel is complete justice on the facts of a particular case. Fourth, the Chief Justice of India has the power of the roster, and actually a whole chapter can be written on what this power really means. It means that he can decide, right, which matter will be heard by which combination of judges, and in that sense can shape the future of the judgment, even in a sense before it starts. And fifth, he presides over the collegium, which is something quite unprecedented in most parts of the world, because nowhere in any part of the world do the judges appoint themselves. These 5 powers amalgamated in one man make the Chief Justice of India the most powerful in the world. Now, when Dhananjay Chandrachud, on the 9th of November, steps into that office, at one level, he will be doing what millions of other people in India have already done. namely step into his father's office. But at another level, it will be unique because no other family has given India two Chief Justices of India. And from the little I can make out of the way Abhinav and Chintan, his children, are shaping, you might well down the road have a hat trick. Now, obviously, the question that arises is when we think of the two Chandrachuds, we have to also see what would be their legacies, what are their contrasting legacies, what are the differences in the time zones in which they became chiefs. So first, Dhananjay does not have the advantage of time that his father did, because his father was Chief Justice for 7 long years, longest ever tenure of any Chief Justice so far, and probably will be the longest for a long time to come. But he has two advantages which his father never had. One, he has the advantage of the collegium system. In his father's day, the collegium system didn't exist. It came afterwards. And two, he has the advantage that Obama had over Clinton. Both of them were very charismatic presidents, but Clinton never had the internet. Today, the internet is such a game changer as far as the Supreme Court or any court of India is concerned. I'll just give you very quickly 2-3 examples. In the old days, you would only hear about the Supreme Court when very, very important cases were argued. So Palkhiwala came down to argue bank nationalization, the papers reported it. Palkhiwala came down to argue the Privy Purse case, the papers reported it. Palkhiwala argued the fundamental rights case, the papers reported it. But otherwise, the Supreme Court barely found its way into the newspapers in that era. Today, what Chief Justice Chandrachud will find is, and which he already knows, that anything that the Supreme Court does, which is of some significance, is within a matter of a few hours, percolates its way down. The impact or the knowledge of what has happened percolates its way down all the way down to, the deepest recesses of India, the lowest people on the ladder, on the economic ladder. So as a result of this today, the judges will find that whatever they say has an impact far beyond what was there earlier. As far as Dhananjay himself is concerned, I mean, you can see from his judgments, he decriminalized gay sex, he decriminalized adultery, he allowed women to go to Sabrimala, he ensured that the right to privacy is now deemed to be an intrinsic right. So you will find his legacy to be that of a modern judge, that of a pro-woman judge, that of a liberty-conscious judge, and I'm sure that it will also ensure that, if required, the court will be sort of a protective barrier against the wrongdoings of any government. That's how I see the legacy of Dhananjay Chandrachud.
Thanks. Thank you for that opening comment. There's one other attribute to Justice Dhananjay Chandrachud. Nobody can say that he's about 63. He looks much younger than his age, is one remark I often hear everywhere. Though there is few times I also heard this about one of my panelists today, Justice Sikri, looks much younger than his age. But I'll also, it's just that he allows his hair to turn white. If he colors, then I don't know. But we are digressing from the issue here. Justice Sikri, sir, your opening comment on Justice Dhananjay Chandrachud.
You see, I think as far as opening comments are concerned, Ryan has beautifully expressed so many things. And when we contemplate his tenure as Chief Justice of India, no doubt in comparison with his father, he will be having only 2 years, whereas his father had 7 years. But going by today's standards, and as you also rightly mentioned in your introductory remarks, in recent times, if we see in last 10 years or so, or even maybe almost 15 years, hardly any Chief Justice had this kind of tenure. I think last, if I remember, was Justice Anand, and thereafter Justice Balakrishna, etc. Those judges were there. Of course, there may be 1 or 2 more thereafter as well. But many predecessors were having a tenure of 6 months, 1 year, 14 months, 16 months. And the Justice Lalit was having only 75 days. He would retire after 75 days. So therefore, by today's standards, 2 years also would be a good period. When we compare it to other countries, maybe it is not, that lengthy that you can do many things which you want. But I think sufficiently long for you to do and bring some judicial reforms if you want. And if I may say, give my, I'll develop on that hypothesis, but verdict on that at the outset that Justice Dhananjay Chandrachud is capable of doing that. Let me say it from three angles, this aspect. Number one, what are his qualifications, attributes, his merits at personal level, some of which Ryan has already described. Number two, what are the challenges which our judicial system faces today and where reforms are needed, and whether he is capable of undertaking those reforms and taking that forward. Number three, the political and social challenges and the milieu in which we are living today. And the kinds of, because of this reason only, many political and social and constitutional matters which are coming before the courts and which are really very, very challenging matters and sensitive matters. So therefore, whether he would be in a position to deal with this in a manner in which it is to be dealt with. Because why I said so, number three, is that the faith or the trust of people of this country, whether he will able to win or not, would depend upon how he performs as far as this sphere is concerned. So coming as far as now to his qualities or attributes, number one, judicial acumen, his knowledge of law, and his knowledge in the constitution, which a person in Supreme Court and particularly Chief Justice of India has to have necessarily possess. Going by that, I think we have to give him 10 out of 10. As far as this aspect is concerned, nobody would say or would be able to say his lack of knowledge in any sphere, any kind of, any branch of law. Be it criminal branch, be it civil branch, be it, commercial kinds of matters, and above all, constitutional matters. He is, the way he has given some of the judgments, and Ryan has already mentioned, I will not repeat that, but let me tell you in one articles which Professor Bakshi has written and which has been published in newspapers recently, I think maybe 2 days ago or so. You started with the word hope. He has labeled that article as great expectations. So what are the expectations from Justice Chandrachud? And there he mentions about his qualities as far as his legal prowess is concerned. And he says that he has made an indelible impression as a widely read academic scholar at home with Indian and global jurisprudence. He is much hailed as a part of constitution benches which decriminalize consensual homosexuality, recognize privacy as a fundamental right under Article 21, and decriminalize adultery, and was part of the majority holding which upheld the right of women of all ages to enter Sabrimala temple. And notably in relation to environmental law and jurisprudence, he has spoken for the court of the need to develop a conscious notion of environmental rule of law, a notion for controlling and combating anthropogenic harm. So therefore, I think these words of Professor Bakshi summarize his qualities as a judge who possesses such a vast and such good knowledge. And going by this, so that is his academic, brilliance. Now, as a Chief Justice of India, he will have to show his ability to administer also on administrative side, because as a head of the institution, it is not only the Supreme Court of India which he has to manage, but the entire judiciary. So, but what I feel is, having seen him as Chief Justice of Allahabad High Court, and thereafter here, of course, when you become senior, you are given some administrative duties as well. Particularly, if you know about, because he has been the in charge of E-Committee for a number of years, and the way he could bring the reforms and meet the challenge during COVID by, I mean, adopting that kind of technology, and he could monitor not only Supreme Court, but all high courts and at district court level also. And as Ryan also mentioned, that technology is one thing which he has now, and which his father was, this was absence in those days. So that not only he has that advantage, but he is quite well versed with this. He's not, nobody can say that he is a person, maybe at this age, many judges, particularly in Supreme Court, say that, sorry, we are not going to learn new things and these technology at this age, and we are averse to it. But he's just the opposite to that. So therefore, what I feel is that it is, I mean, on judicial side, when number of cases, etc., which come and challenging matters come, he has the ability to handle that. And on administrative side, he has the ability to tackle various I mean, further various judicial reforms. I'm not enlisting the reforms, etc., which are needed at this time. So that is second thing. And third is, as I mentioned, about the kind of cases which may come. And today, apart from the cases which he has already done, and me and Ryan have mentioned about this, but we know Sabrimala review case is pending. It is. We know that this hijab matter, the split verdict which was given, now it is again going to be referred to the larger bench. It has been referred, and therefore that has to be done. So constitutionality of citizenship, that matter is pending. And very interestingly, I tell you, very old matter which is pending is definition of industry under the Industrial Dispute Act, which was referred maybe 20 years ago to a larger bench, but I think to 9-judge bench, and which has, I mean, we have quite a few, we talk of constitutional bench matters means 5 judges, but we have quite a few 7, 9, and 11 and 13-judge matter also, which are yet to be, at particularly 9 and above benches, yet to be constituted and done. So whether he would do that and will show that, look, we should be able to lay down clear law because of, and I tell you, as far as definition of industry is concerned, and particularly whether educational institution and these say scientific institutions, etc., charitable institutions should be treated as industry or not. This matter is pending, and various judgments from different courts, conflicting judgments are coming. And in many cases, the cases are just lying that way, awaiting the judgment of the Supreme Court. So therefore, and then conflict between legislative privileges and freedom of press, this matter is pending. Then, of course, where he was himself a party, and I think that he will definitely do, whether this on the Finance Act, whether it's a money bill or not, that matter which is referred to the larger bench. And validity of electoral bonds. Of course, we should not undermine the I mean, task done by Justice Lalit in his I mean, even in such a short tenure, because he has, at least he started the process, and many cases are already listed, many are already underway and listed before the constitutional benches. But then some of these matters are still to be brought there, and people are looking about these matters. So that is another. And I would only here in my preliminary remarks and with this, that we have some of the challenges which our society is facing today. We have the problems of hate speech, speeches, minority rights, and the challenges regarding free speech, which is right to dissent, etc., and leading to other types of cases which are registered against people. He has spoken a lot about all these issues at public fora, but when the matters come before the court, how he is able to lay down a law himself or through his colleagues in some other benches. So these are some of the aspects, and I think if he is able to do it, he should be able to do it in a remarkable manner.
Thanks for the detailed opening comment, and thanks for taking the, in a sense, initiative to list out the cases also which are important. Appreciate that. But also the intellectual endorsement you gave to Justice Chandrachud is heartening, because you yourself are a gold medalist from college days. Is a lesser known fact that this was in Sri Ram College, if I'm not wrong. That Justice Sikri received the gold medal. So it's from one intellectual
to in law faculty.
In law faculty. So it's from one intellectual giant to the other. I'll go across to senior advocate Parag Tripathi, and you have had the pleasure of knowing Justice Chandrachud because you studied in the same class, and in a sense, both of you chose to come back to India in those days when nobody was coming back. People were going abroad. This is pre-liberalization. You chose to practice law in this country. And we see that now you're at the top of the totem pole of the bar as a leading senior advocate of India, and he is the Chief Justice of India. Could you reminisce the older times, and also on our theme of hope, what hopes do you have from Justice Chandrachud?
Yeah, my one little problem is that both the illustrious speakers before me have, to use a legal expression, covered and occupied the entire field. So I feel like saying I concur and sit down. Since I'm already sitting down, may I make my small contribution here?
Then you stand up.
Yes, sir. Now, let me just reverse the question. You know, the Chief Justice, Ryan, very admirably set out the various functions. There are 4 aspects of the functioning of Chief Justice, of a Chief Justice of India, which are crucial. Ryan has, of course, dealt with it, but I'd like to just put it in a different perspective. One is the purely judicial role as a judge. So you have to have that intellectual capability. You have to have the commanding heights of intellect, which will generate that respect. And Justice Sikri rightly said he has that. So that's one, is purely judicial functioning. But that has to be also considered along with the views of the judge in his various articles and public speeches. So that's one aspect. The second aspect is the collegiate function and collegiate focus, not only appointment of judges to the Supreme Court, but to the High Court, which is unique, of course, to India. And remember, collegium functions as a collegium, and he will have the benefit of a very, very powerful collegium, including the senior most member after him, Justice Sanjay Kaul, who was with him in college for 3 years and in law faculty for another 3 years. So this is a very powerful collegium, and which will, of course, shape over his tenure a large part of judicial appointments, because there are a lot of vacancies. The third is a purely administrative acumen, which is a totally different hat. It's like, to give a very loose analogy, a great batsman or a great bowler will have to additionally, as a captain, work out his resources to the best possible benefit. And that's not easy. It's easier said than done. There, not only do you have these issues of arrears, as Justice Sikri said, the issue of transparency under the roster system. Ryan rightly said, one very distinguished commentator had said that in India, we have Supreme Courts, because each of the benches many times will have totally different views on various issues. So transparency in roster is a very big issue, particularly in this internet world. But there's a fourth aspect which is very important, and that is sometimes completely overlooked. And that is the institutional interface of the Supreme Court or the judiciary with the government, with the executive. Because this is not meeting here and there. That's not the point. There's an institutional interface for smooth and harmonious functioning, which is very important. And that institutional interface naturally has to be with a broad judicial consensus as to what should be the broad areas of that interface. I remember there's a very interesting article by Justice A.P. Shah who retired as the Chief Justice of Delhi High Court, where he said that this interface, which I call the interface, is based on constant shifting and rebalancing and recalibrating of power between the judiciary and the executive. Now, this becomes very acute and in a sense very different when you have a single powerful party in the center. It's not a question of right and wrong. It's a question of interface and how best to take steps, which is with consensus and for the benefit of the country and the institution. That's an art in itself, which is a very important art. Also, I remember Professor George Gebois, that's how he would pronounce his name, had said that what is it that you expect of a Chief Justice? So what you expect of a Chief Justice, he said, is an extremely competent administrator, a great jurisprudential scholar, and a shrewd judge of men and personalities, and a towering personality himself. So this is quite a wish list, which of course, we have no doubt that the incoming Chief Justice will fulfill, but it's a great art which requires continuous focus and continuous attention to all the details, particularly in today's world. So these are the various aspects. As Justice Sikri rightly said, we have had tenures of 7 years plus of Justice Chandrachud, the senior, if I may use that expression, that is the father of the present incoming Chief Justice, to about 17 days, which was there with Justice K.N. Singh. So ultimately, it depends on your focus and how you leave an impact. Because Justice Sikri said, for instance, Justice Lalit has made a very significant impact despite a very small number of days available to him, of certainly an impact of intent, because impact need not always be of effect. Impact of intent is as important and as crucial for an institution like this. I have had the pleasure, of course, of being in the same class with him for almost 7 years. And he continued to study. I gave up studies at that point of time and came back to India. Now, extremely hardworking, very focused, actually exactly as he was now, including, of course, an amazing quality which I never understood of practically never sleeping. So very limited sleep time, unlike me, who's a complete sloth. I prefer my 8 full hours. So he's been always like that, very focused, very determined. And if you look at his judicial dissents, his judicial majority judgments, his ability to carry the bench with him, these are all very interesting indicators. And as Justice Sikri said, some of the matters which will tickle his intellectual, if I may say so, curiosity and taste buds are there on the anvil, and it will be very interesting to see how it pans out. But before ending, I must say that even though Gebois has set this standard of what a Chief Justice should attain, it is the greatest personal achievement a person can have in our system, in our judicial system, which includes the legal system in its entirety. And I end with a nice couplet which says, which brings in the hope as the great hope or the great expectation, as again Justice Sikri said, was the subject matter of an article of Professor Bakshi. We used to steal in and listen into his classes, though he was not teaching at the campus law center. And it is, "Tu Shaheen hai, parwaz hai kaam tera, tere samne asma aur bhi hai." To put it in a very simplistic way, you are a falcon and your status and place is right there. So that is what all great judges, including Justice Sikri, aspire for and achieve. And we have no doubt that this will happen again. And once again, I think we are very lucky to have such a strong collegium here, because each one of the people in the collegium is a personality and an independent jurisprudential scholar in his own right. And that will make things very, very nice for the institution.
Thanks for that elaborate and introduction where you shared various aspects and expectations. Also, I'll go to Mr. N. Karanjawala, Managing Partner of Karanjawala and Company. Justice Sikri spoke on digital courts, e-courts, and being close to Justice Chandrachud's heart. Now, you represent one of India's leading litigation law firms, and we have in Justice Chandrachud a judge who's pushed the e-court system. And there's lots of hope that, infrastructure-wise, money-wise, I don't think there's going to be any shortage. But I want to ask of you, in today's times when the client's needs are changing, when somebody might want to be in London and still make his counsel appear, or in Bombay, or clients might not prefer to fly down for just a small appearance. Do you think that the great sea of change that we are going to witness in Justice Chandrachud time is going to leapfrog the judiciary into another level of interface with the people as far as the digital ecosystem is concerned? And what are your expectations on that issue, and any suggestions that you may have for that?
So definitely, there's no doubt that COVID, this is really a COVID change. COVID
Okay.
has brought about this change in the way that we look at our courtrooms and how they function and how counsels come in, how clients witness and watch. And it's certainly a change for the better. The advantage that Dhananjay Chandrachud had was that he sort of took to it like a fish takes to water. He grasped it, he understood it, he digested it, and he applied it. And that is something that puts him slightly different from some of the other judges who are not as familiar with the e-systems as he is. He will certainly take this forward further. And in the years to come, you will certainly see a lot of changes because the internet itself is not just a matter of how you argue in court. The internet is a system about how your voice in court ultimately reaches the people. In the old days, what used to happen was, very simply put, you wrote a judgment and it stayed in the library books, it stayed in the books in the library. It was discussed sometimes in court. It was discussed sometimes in the canteen. But by and large, it did not permeate throughout. Here, what will happen is because of the internet, because of the increased sort of interest that people have in what the court is doing, because of the increased importance of the court in the things that it does, because the judgment of the court impacts so many different people, it impacts so many different lives. People are now just sort of listening in, going on the internet at their own time and space, logging on, seeing what was argued, trying to understand what the effect of the judgment is, and so on. So suddenly you have a situation where in the years to come, people will find that in a sense, the Supreme Court is in everyone's drawing room because now you have live streaming. So just as people sometimes switch on to the parliamentary system, sometimes people will just switch on to see what is happening in courts. And this will bring about a whole new paraphernalia of, you know, ways of behavior, how, because you are now being viewed by the world. It's a fishbowl existence. So you have to say, naturally the courts themselves will sort of liven up to the situation, that the heat of the debate will go down, the scholasticness of the debate may go up, it may be put in more simplified terms. There are a whole lot of things that will happen. And these are changes that will keep happening and they will happen for the better.
I want to have one small comment from you, Mr. Karanjawala. Now, you engage some of the top councils of this country many times, and they have different forums to argue before. With digitalization, do you think that eases the issue? Because you can't be running from one forum to the other, from the Supreme Court or the
So
High Court to a tribunal.
don't look at it from the point of view of top counsels. Look at it from the point of view of the litigant. So you have a litigant in Bombay who's been wanting to bring a top counsel down, whether it's a Singhvi or a Salve or a Rothgi or a Sibbal or whoever it is. And he just doesn't have the wherewithal because physical bringing down of the counsel is a huge uh, expense. They're much cheaper when they come on Zoom. Now, he then has the advantage of virtually having the full attention of the counsel for that limited period of time when he's on Zoom and having the benefit of his argument at a much cheaper rate. So while the counsel may find it easier, the litigant also benefits. It's not just the benefit that the counsel has. Now, sitting in Delhi, he can argue in Goa and Patna on the same day. No, this is a benefit that goes to the litigant first, because the litigant now has a much wider choice of people. And at the moment, the thing is all Delhi centric. From Delhi, councils are going to Bombay, councils are going to Hyderabad, councils are going to the well-known council. But in the years to come, you will start suddenly finding that well-known councils of the high courts are being called to other. And suddenly, a whole new gamut of people available to the litigant is there. And the sophisticated solicitor or the sophisticated firm is able to sort of ensure that the client gets the best deal eh, in the best possible way.
And we see that a lot of investment in infrastructure creation will go in Justice
It
Chandrachud's.
has to, and it should.
Okay, I'll go to Justice Sikri. Sir, now you have also taken to, in a sense, the digital arbitration mode like a fish to water. Everybody in the industry talks that how extensively for hours you are before your computer and you're holding arbitrations as presiding arbitrator, and people appreciate that fact. So if you can do it, do you think a lot of judges where there was a certain hesitation can now with Justice Chandrachud's push take to the e-court system? And how do you think it will benefit the litigant? And do you think Justice Chandrachud has the wherewithal to put in a nice budget, because this all we need a couple of thousand crores? Do you think, because you have been in the system as a Supreme Court judge, do you think that money can be brought in and the transformation done for all high courts of this country along with the Supreme Court? And also share your experience of how you have, in a sense, how the client gets helped when you agree for a digital arbitration. If you can mix the both of two in your answer.
Your question on whether he can bring, yes, for computerization and online courts and turning it online, lots of investment is required. And your question whether he can bring it or not, of course, purse is always the government. And here, what Parag said, that interface between the judiciary and executive, this is one of the aspects where it kicks in. And what I would say that going by the, mindset even of the government to bring, they are going, at a very fast pace insofar as digitalization is concerned. If digitalization, the government can push it in all other fields, I don't think that they will have any reservations when it comes to digitalization or online courts is concerned or judiciary is concerned. So therefore, I think kind of persuasion, and when Chief Justice says so to the government and the government is also inclined, this should not be a problem. That is what I feel. And and let me tell you, and the COVID has of course taught us that COVID became the reason where it was compulsory to have online hearings. We had no other choice. But then it has taught us that even if in normal periods, we can, there are many advantages which the online system has, and we can always have hybrid system. And let me now share, as you have asked me, my experience in the arbitration, which can be easily replicated, and it is being done also in many courts, and many high courts are doing, and I think Supreme Court is also doing that. That is, when we talk of hybrid, it can be in 2 or 3 ways. Number one, in a case, in an arbitration case, before the case reaches the stage of evidence, and thereafter arguments, there are other kinds of hearings. There are what we call CMCs, this case management conferences, or preliminary hearings or procedural hearings we call in our arbitration. And so for all these hearings, there are many times that 3 arbitrators, they may be from different cities. I'm not talking of international arbitration. So far, I'm only confining to domestic arbitrations. But suppose seat is Bombay or seat is Delhi. So they are coming to Delhi, parties are coming to Delhi from various places, staying in hotel, and insofar as the expenses of the arbitrators are concerned, meeting those expenses, all that can be avoided when we have these kinds of procedural hearings, and those can be, and people are accepting it. Because as Ryan also rightly mentioned, first, the advantage of litigants. So much expenditure or so much money is saved when hearing takes place. So same thing can happen even in judicial hearing, because a case, whether it is in the court or before the arbitration, it's an adjudicatory process. It has to undergo the same stages. So that is one thing. Now, when it comes to and it would include arguments of miscellaneous arguments on certain applications, etc., which are very conveniently done. When it comes to this evidence, again, there can be a choice. There is possibility, there may be some cases where documents are in thousands and the witness is to be confronted, and the question of whether the witness should be tutored or not, those issues may come up, and there where the in-person or physical hearing may be required. But from my experience, I say that 50 to 60% cases in arbitration, we are easily able to do it online. And here now another hybrid which in arbitration we are doing. Even if suppose in-person hearing is required and the witness is to be present. Now I have seen we adopt hybrid mode where the arbitrators can be online. Many times one or two advocates of the parties are also online, and the witness and the advocates of two sides are sitting in a room at one place where they have booked, and so they are physically present. That it is not necessary at the time of evidence that all lawyers or main or senior lawyers should also be there, and a person who is cross-examining or other person who is showing the papers to the witness when he is confronted with certain documents, they can be there, and others can again join. So therefore, it again entails savings of so much of expenditure or money. And at the similar thing can happen at the time of final arguments also. We have done, and in international arbitrations, in any case, it has been practiced for quite some time. So therefore, in the courts, whether it is High Court or district courts or Supreme Court, where some of the hearings can take place, because we are having hybrid system in the courts also, where a person is, an advocate is not able to come or a party is not able to come, they appear online, that access is given, and those who are able to come to the court, they are coming to the court. So, and with the live streaming and the people, when they are allowed to join also, and online system is still there. So this is happening. So therefore, and in this context, as you say, rightly mentioned, the as far as mindset of Justice Chandrachud is concerned, he's very clear about it, as I understand. And where, if you remember in that case, which was listed before him, and he's supposed to hear the arguments. I don't know which is the date fixed now of that Delhi government versus Union of India about the status of Delhi government under our constitution, which is referred to larger bench. And to him now, he had made it clear. And it was an interesting, a very rather challenging task given to the lawyers also, to tell them that, look, what is there in for you in future. He said that it would be a paperless case. Neither we would be having a single paper before us, nor we are allowing the advocates to bring a single paper. So they should come with their laptops or their iPads, and they should argue. So if we can make lawyers also agree on that and not tune to it, then you can understand what is in store in future. So therefore, it is, and online courts is going to happen, whether it happens today, after 10 years, after 15 years, 20 years, either in hybrid form or other form, or maybe where 50-60% cases are done online. That is going to happen one day. And I think Justice Chandrachud would take lead in that, in spearheading that moment.
The beauty is in Justice Chandrachud period, as you said, we will leapfrog as one of the countries that have, like the developed countries, have adopted digital fully, in a sense. We will see how that happens. I'll go to Senior Advocate Parag Tripathi, and your comment on, I remember having spoken to you one of these days when you had to go to Hyderabad for an appearance, and there was no option for arguing digitally. So do you think that with someone like you, who's a top counsel, to be in Supreme Court at some tribunal in the High Court, then you fly off to Bombay or some other Mumbai or some other place, how does the digital ecosystem help the client and also the top counsel? And what do you think Justice Chandrachud could do to make it a success? Because of course we see that this is one area where he's going to drive change.
Yeah, you see, don't just limit, I like your expression, digital ecosystem. Don't just limit the digital ecosystem only to clients and top counsel, because by that alone, it can never succeed. Even by a well-intentioned judicial push. it has to be to the bar at large. And in my view, the digital ecosystem actually helps the bar at large. Quite apart from senior counsel. See, they can do 4 matters, they'll do 8 matters. That's all right. But the bar at large benefits because it does away with the inequality of rentals. You don't have to have great posh offices. You don't have to have great transport. You can be wherever you are and you can address the court. And you can always be there. With 2 computers or 3 computers, you can track 5 different courts. So therefore, for the young people who are up and coming, because ours is a pyramidal structure, there's a lot of talent as you go down from the top. So they get a great advantage of visibility also. I find particularly in my parent High Court, the Delhi High Court, it has been a tradition for a very long time there that one good argument of an unknown junior counsel makes it. And then he's talked off when the judges sit for lunch, they say, this boy or this girl is really good. Huh? She argued very well before me. Therefore, digital ecosystem gives the opportunity to youngsters also to showcase. It also relieves a huge burden from the registry. It avoids unnecessary adjournments. Take a case where you say that the related file is not there. How many times in my younger years, or my even younger years, the matter would be adjourned because the related file is not there. Now, as you improve and advance, with a click of the button, you will get that file. So all the various nuances which we as arguing counsel have found to get a matter adjourned and the fee safely pocketed will all be taken away, and rightly so. But that's very important. You have to, once a matter comes, because there are several judges who believe that, both in the Delhi High Court, Supreme Court, and I'm sure other High Court, that once the matter comes, then now we want to dispose it of. There's no question of adjournment on this or that ground. But I find that as you move away from Delhi, with a few exceptions in some of the leading high courts, most high courts, there is a resistance for this digital ecosystem. But I think that happens to any new idea. As Justice Sikri rightly said, the digital ecosystem was thrust on the judicial system a little ahead of its time. It's like when India became independent, we took over democracy from a feudal setup. So it takes a little time to adjust. Likewise, in the judicial system, it was thrust on us, but I think we are adapting well. And maybe you can even do a system where in the first half, you have a system which is of digital. And in the second half, when you go into final hearings, you can push your final hearings back or bigger admission matters back to second half where people can come physically. So it's a great advantage for everybody. And of course, the lawyers will have to, as Justice Sikri and my good friend Ryan pointed out, that the lawyers will also have to shape up, which is good, because I think on the job, there's nothing like on-the-job training. And as one wit had said, the legal profession is the only one where you get paid for your on-the-job training. So I think it augurs very well for us. We have to be a little more hospitable in the bar as well, and also in the wider judiciary to the digital system. Of course, it has hiccups. There's no doubt about it. It has hiccups. It has problems. Sometimes people just butt in a loud voice without understanding what is happening in the court. But I find that most judges are extremely kind there. They will just make it clear that if you don't butt in like this, it will be probably better. And of course, the hint is taken. So I think Justice Chandrachud, with his focus on the digital ecosystem, will be a great benefit to the system.
Thanks for your intervention. Now we're almost out of time, so I'll request a final comment from each of my panelists, which would be in order, and a final parting comment on Justice Chandrachud's taking over. We'll start with Mr. Karanjawala, and when we come to Senior Advocate Parag Tripathi, we'll look forward to another couplet if he's managed to fish out one.
Before I sort of speak a little about Justice Chandrachud and what we expect from him, there's one thing that when Parag mentioned that he hardly ever sleeps, then that is something that he has in common with his father, because Senior Chief Justice Chandrachud was also virtually insomniac. So it seems to have been inherited from him, from his father. Those genes seem to be similar. Now, as far as Justice Chandrachud is concerned, I expect that at the end of 2 years, when we look back on his legacy, we will, and I hope, he will have left the court more independent. He will have left the court a kinder place, a more pro-women place, and certainly a more modern place. His outlook is that of a modern person, and that is the direction which he'll take the court. He's also a person of, he's had one other advantage, which a lot of other people don't, which is in his early days, he sat on the breakfast table of a judge of the Supreme Court and of a Chief Justice of the Supreme Court, when his father was a judge and when his father became Chief Justice. So at that stage, there's a lot of learning that you do behind the scenes, which comes in use when you deal with the same situation later, if you deal with such a similar situation, which he will be. So I expect him to be able to handle the judges, bring his collegium around, and the most important thing for him to remember is that he has to ensure that the court is at full strength. Because
Yes.
unless the sentinels are on the citadel, then the fort of justice is never going to be defended. So your first thing is to see that you must ensure that as many judges as possible are appointed. And for that, he will need a skill, which I think he has.
Right. Point well taken. And Justice Sikri, we move to Justice Sikri for his closing comment.
Yes, I think, Tarun, what Ryan has said, I also expect when we are talking about, and this program started with your using the expression hope, and then myself borrowing the expression of Professor Bakshi of great expectations. And we not only there are hopes and great expectations from him, but we have some trust in him that he will be able to deliver the goods. As Ryan has rightly mentioned, appointments is one thing which needs to be taken care of, and there should not be any vacancies, and all should be filled. And it should not only be at Supreme Court level, but at High Court level and at district courts also, because entire judicial system needs that kind of, as far as appointments are concerned. And I will only add one thing. Yes, he will be able to bring or ensure more gender parity while making these appointments by giving representations to women also at all levels. We are going to have after a few years the first woman Chief Justice of India, but I hope that there would be many women Chief Justices in various high courts have seen, but there should be more Chief Justices, women Chief Justices, and other judges at all levels. So that is one thing. And other is that when we talk of judicial reforms, I am going to talk about here only that even judicial education and judicial training. We have National Judicial Academy, and I'm sure that he will look after that as well, as he has been very active in National Judicial Academy. Then legal services and to the poor and access to justice. He has been talking a lot about access to justice. So therefore, NALSA should be strengthened in that way. And here also, the purse of the government has to be loosened, and some money should come for schemes, more welfare schemes of NALSA insofar as access to justice is concerned. Another thing which I feel that we need to have many reforms in criminal justice system. And particularly apart from any other reforms, and I'm not talking of delays, etc., which are talked about every time, and we have to look after that. But we have to, insofar as, again, the legal service which is to be provided to accused persons, the defendants who are accused of crimes, the defense the defense lawyers who are provided by the courts or by our legal service system, they have to be. I have seen in America, the defense counsel sometimes are the best provided by the state, and they should at least match the acumen of the prosecutors, and it should not be. So therefore, training of these, and this is also one of the aspects which needs to be looked into in order to strengthen the criminal justice system. So these are some of the aspects which, apart from what Ryan has said, and I think he is one person who will have 360-degree view of the matter, will touch upon all the issues which need reforms, and he will try to do that. And as far as only one thing, which I had said earlier also when we were talking about Justice Lalit, who was to come, that when it comes to Supreme Court matters, we have to have case management at that level. I feel, and this would be my advice to Justice Chandrachud also, when cases are fixed, particularly, say, take an example, on Tuesday, this miscellaneous, which is after notice miscellaneous matter for final disposal. We should not have 10, 20, 30 cases fixed, which it is difficult to finish all those cases. And even if 3 or 4 cases are finished, or they are argued, but others are adjourned, and if they keep getting adjourned from time to time, it not only brings dissatisfaction to the litigants, because they have to engage counsel in any case, and they keep paying that. So why not have case management where beforehand you ascertain from the lawyers how much time they will take, stick with that timings, be firm about that, and give them the date of their choice, and then don't adjourn. So then even if 3-4 cases during that period which are required to be done, they should be done. If the cases are on board, they should be done. And this kind of case management is very much required, not only in the Supreme Court, but at High Court level also.
Thanks for sharing that input on the case management system. We have final comment of the day by Senior Advocate Parag Tripathi.
I think I can only sum up what has been very ably said by, as I said, my illustrious speakers before me. What you really need is effective access to justice. And the way to achieve it is by having as complete a digitalization of the court processes, with a diverse judiciary coming from diverse background, and full strength court, rather full strength courts, both in the Supreme Court and in the High Court. Now, these are very difficult things to achieve. In the Supreme Court, we did have a full strength court for a bit, but High Courts, it's far from a full strength court. And I particularly like the expression used by Ryan, that is a kinder ecosystem in court. Because ultimately, particularly in the Supreme Court, a man has fought for 10 to 15 years, maybe much, much more. And a swift dismissal in half a minute sometimes doesn't go too well with the well-known principle that justice not only must be done, but be seen to be done. So I think that is also important, that I remember in the olden times, we had judges who would say, oh, this is the point you're making. Well, we understand, but sorry. Now, that at least softens the blow, because we know that in an SLP admission day in the Supreme Court, there will be a fatality in excess of 80%. And lastly, the point which Justice Sikri made, that access to justice would also require, I put it as a part of access to justice, to have an efficient, competent, modern case management system. Because that is fundamental. You've got limited hours. You've got ultimately a limited number of judges. You can't expect them to work like nobody has worked before. That's not fair. It doesn't work like that. So you have to have a case management system, which I'm sure, if it is all put together, will go a very long way.
Thanks for that final parting comment. But we wish Justice Chandrachud well. He takes over as the 50th Chief Justice of India for a 2-year tenure. And fate ordained it for him. Nobody knows that he's going to become the Chief Justice of India. He had it, fate had ordained it for him, and he's going to be India's Chief Justice. I would like to thank Justice Arjun Kumar Sikri for making time for this episode. Senior Advocate Parag Tripathi, Ryan Karanjawala, Managing Partner of Karanjawala and Company, and viewers, appreciate your joining us for this 2-part series. Thank you so very much.